Good afternoon. A very warm welcome to all of you to this seminar on the prison rules hosted by the Irish Penal Reform Trust. Thank you very much indeed for joining us. Our warm thanks to members of the Judiciary and the Oireachtas who have joined us today, as well as those working in prison and penal administration. I extend an especially warm welcome to IPRT members and friends. My name is Mary Rogan and I'm an Associate Professor in Law at Trinity College Dublin, and it's my great privilege to chair today's events, not least because of my great respect for IPRT and its work, but also because this topic is one of immense importance to the functioning of our prison system. It's central that we shine a light on the rules that govern the administration of our prisons and provide a forum for critical reflection on what those rules should contain. Thank you, IPRT, very much for this opportunity. As you know, our prison rules date from 2007 with some subsequent amendments. Their predecessors were, of course, the 1947 prison rules. So it took 60 years to amend the first set introduced by an independent Irish government and around 14 or so for the second set. That first set of rules from an independent state in 1947 came about after a great deal of controversy about the treatment of prisoners. Let's hope this opportunity to amend the rules can take place in the context of considered dialogue, taking account of best practice and international developments. The prison rules are really important for many reasons, but to name just a few. First, though, as we will hear, the ability to litigate them directly is somewhat limited, the rules must shape judicial understandings of the obligations to prisoners. Secondly, they are a benchmark, the basis for standard operating procedures and prison protocols, and something against which prisons can be measured, I should say. So if we are too limited or narrow in our ambition for them, that can affect inspection and monitoring practice, for example. Third, they say something about our attitudes towards compliance or otherwise with European and international norms. But they are also full of symbolic meaning, and the historians of tomorrow will judge our attitudes to prisons and to people in prison through the lens of those documents. So I'm very glad we're talking about them. A word on the format for today. Sadly, we can't see our attendees and all of you are muted, but we know you're there. Hello. But we do very much encourage conversation in the chat box on the screen, and that will be moderated. We will also be delighted to take your questions through the Q&A box. It's my job, and I'll do my very best to get to as many questions as I can and put those to our panelists. And there will be two opportunities for Q&A throughout this evening's event. Please do keep that Q&A box for questions. You can chat away in the chat box, but do keep the Q&A box for questions to give me a little bit of an easier time. And do also remember to have your name on Zoom set as your real name and your organisation if that applies, so that the people in the chat can see who they're talking to. You can also tweet using #PrisonRules. The event is being recorded, so please do not record it yourselves. And if you lose connection at any stage, just click the webinar link that you have once again. So today's events will be in two parts with a 5-minute or so break in the middle, concluding everything by 6 p.m. And it's my first very pleasant task to introduce Molly Joyce, who is the Legal and Public Affairs Manager at IPRT. Still quite a recent appointment, so we extend our congratulations to you, Molly, and welcome. And it's a testament to your work that these prison law seminars have come back to life in such an invigorating way this afternoon. So thank you very much. Molly, it's over to you.
Thank you so much, Mary, and thank you all so much for attending the first in IPRT's 2021 Prison Law Seminar Series. It's great to see such high numbers in attendance. And as you all know, this is also the launch of our Know Your Rights Guide for prisoners, which you can see here beside me, but which is also now available online. And as Mary has said, I have only very recently joined IPRT at the end of last year as Legal and Public Affairs Manager. The Legal and Public Affairs Programme is an exciting new project for IPRT. The core aim of the programme is to inform and influence legislation, policy and public debate through research, engagement with legislators and criminal justice actors, and engagement with the legal community. Of course, much of this is not new for IPRT, and what I will be doing is building upon IPRT's strong track record in producing rigorous, evidence-based research, which we can then use for engagement with key actors. The Prison Law Seminar Series will also not be new to many of you in attendance today. It has been a key part of IPRT's engagement with the legal community over the past 10 years, and we are really delighted to be reviving the series today. Our hope is that the series will continue to be a source of information for those practicing in the areas of prison, criminal, public and human rights law, as well as providing a platform for practitioners, academics, civil society actors and state actors to exchange ideas about the ways in which we might be able to reform and improve our criminal justice and penal system. We hope to host at least 2 seminars per year, and we do hope that you will join us for future events. For today's seminar, as Mary has already outlined, we are focusing on the Irish prison rules. Mary has already very eloquently outlined why these rules are so important, and our first speaker, Damien Coffey, will also give a bit of background to these rules. But I just wanted to very briefly explain why it is that IPRT chose to host this first seminar on this underexplored issue and topic. The prison rules, as Mary said, are made pursuant to the Prison Act. The current prison rules are made pursuant to the Prisons Act 2007, and they effectively set out the conditions for life in Irish prisons and regulate the practical matters which govern day-to-day prison routine. To say, however, that the prison rules merely provide a framework for how Irish prisons should be run is to understate their importance. As Mary has said, rules can also be a source of rights for prisoners, and they can guarantee a certain minimum standard of treatment for prisoners that they can expect when they are in custody, and on the basis of which they can challenge prison authorities when those standards are not met. Given their importance, it is perhaps surprising then that the drafting of the prison rules, this potentially crucial rights-setting document, has historically been an internal government process driven by the Department of Justice and the Irish Prison Service. It is perhaps also surprising that amendments to the rules have, in our experience, received very little public scrutiny. An example of this are amendments that were made in July 2020 in response to the COVID-19 crisis. These amendments effectively allow the prison to modify, restrict, or suspend entitlements to physical exercise, recreation, training, and visits in order to deal with infectious disease. These amendments do not have a sunset clause. They are not specifically limited just to COVID-19, and they do not appear to have received any real scrutiny from the public. These are matters of concern for IPRT, and it's our view that there is scope for the prison rules for there to be increased transparency around the prison rules about how they are devised, how they are amended, how they are updated, and in addition for key stakeholders to have some input into that process. Today's seminar is simply aimed at starting a conversation about the prison rules by hearing from those in the front line of prison litigation and also hearing from those in the public and international sectors. And our hope is that it will start an ongoing conversation and increase focus and awareness of the prison rules and their importance. I'll hand back to Mary now and let us get on with hearing from the experts. But just another note, a brief housekeeping note on CPD certificates for any of those practicing solicitors and barristers in attendance today. We are, of course, very happy to provide CPD certificates to anyone who needs them. If you could please just email info@ipirt.ie by the 12th of March, that would be great. And I'd also just reiterate what Mary has already said, which is to ensure that your name and your full correct name is on your attendance at this webinar, as we will be using the Zoom attendance list in order to verify attendance before sending out CPD certificates. I hope you all really enjoyed the seminar. I'm looking forward to a really interesting and engaging discussion, and I'll hand back to you now, Mary. Thank you.
Thanks very much, Molly, and thanks for starting the conversation so well. So let's turn to our first speaker. So for the next 10 minutes or so, we will have the pleasure of hearing from Damien Coffey, who's a senior associate at Sheehan and Partners, the renowned criminal defence and human rights firm in Dublin. Damien has extensive experience in both criminal and prison law and has also volunteered on various projects with the ICCL and IPRT, including on the Know Your Rights Guide for Prisoners, which is a wonderful document which is being launched today. So thanks for that, Damien, and it's over to you.
Thanks very much, Mary, and good afternoon to everyone. I'd like to thank the IPRT for asking me to speak today and wish to commend them on their work, both with the Know Your Rights document and their work over many years in the recognition and improving of prisoners' rights. The Know Your Rights document was first drafted in 2012 and is a step-by-step guide for prisoners, and in conjunction with NALA, the IPRT have attempted and succeeded in making this a comprehensive yet accessible guide to what is undoubtedly for any individual a stressful and incredibly discommoding period in their lives. The prison rules are the statutory basis from which the prisoners of this country derive their rights while in custody. They act as the rules that bind both prisoner and prison staff and codifies what is acceptable, what is expected and achievable by both parties to the process. Their contents range from the size of a cell to the duties of the chaplain, and what the Know Your Rights documents attempts to do is simplify the legal language and guide a prisoner from his or her first steps in custody to the conclusion of that detention. And they do that in such a way as the document reads from start to finish in the most simplified and accessible manner possible. Its importance to practitioner and prisoner alike cannot be overstated and will be expanded upon by Matthew and David as a tool for enforcement and vindication of prisoners' rights in the courts. What I wish to discuss is not specifically what is contained in the prison rules, but rather the gap between what is provided for in the rules and what we as practitioners are instructed by our clients is the norm within the prison, before briefly moving on to discuss how COVID-19 has served to further curb these rights. At all times in working with the IPRT, I'm reminded of the quote that a society should be judged not by how it treats its outstanding citizens, but by how it treats its criminals. And I ask rhetorically how far we are away from a desirable standard to be judged upon, when as I speak, prisoners in this country continue to slop out. A practice that thankfully is now contained to very few, but I think I would speak for most when I say that any single prisoner in this country slopping out is one too many. It is beyond the scope of this talk to point out that to be compensated years later in a sum capped at about €7,500 for defecating into a bucket in front of other people is, whilst not comparable to the insult of the forced act itself, certainly not commensurate, in my opinion, with what these individuals were subject to do and the lasting effect it's had on them both physically and mentally. Slopping out was and continues to be, in the simplest sense, a blatant disregard for the prison rules, not to mention any individual's human rights. And it also, unfortunately, serves to underline how aspirational both the prison rules and this document truly are. The biggest and central problem I have with the rules is the huge caveats which unfortunately and regrettably feature heavily. Those being subject to the discretion of the governor, or the catch-all, subject to the maintenance and secure order of the prison. I'm not suggesting that we live in an ideal world of absolutes, but I am saying that as a practitioner, we see these words used more and more, and their repetitious presence to deny prisoners' rights should be of concern to us all. For example, if one is to turn to Rule 27.1 in relation to out of cell time, it states, quote, subject to any restrictions imposed under and in accordance with Part 3 of the Prison Act 2007 and Part 4 of these rules, each prisoner shall be allowed to spend as much time each day out of his cell or her cell or room as is practicable, and at the discretion of the governor to associate with other prisoners in the prison. It would be difficult for a single sentence to contain more caveats and would leave most legal advisors wondering exactly what a prisoner is entitled to when it comes to out of cell time. We move to consider telephone calls. The governor may permit a prisoner to communicate with members of his or her family or his or her friends by means of telephone calls for such period or periods of time and in accordance with such procedures as the governor shall determine. Subject to the availability of facilities, a convicted prisoner who is not less than 18 years of age shall be entitled to make not less than one telephone call per week to a member of his or her family. This section is again similarly caveated, and that is only the first 2 of 8 subsections relating to same. Possibly the most worrying and broad-ranging caveat enclosed in the rules centres around Rule 62. Rule 62 governs the removal of a prisoner from structured activity or association on the grounds of order. Under this section, the governor may remove a prisoner from engaging in authorised structured activities, participating in communal recreation, and associating with other prisoners where information has been supplied to the governor, or the prisoner's behaviour has been such as to cause the governor to believe, upon reasonable grounds, that to permit the prisoner to so engage, participate, or associate would result in there being a significant threat to the maintenance of good order or safe or secure custody. It provides for a period of 7 days, which can be renewed for 2 periods of 7 days before any obligation arises to notify the Director General of the prison. And all the governors must do all the governors must do to form the above vague opinion founded on entirely subjective belief or inaccessible similarly vague information, and then simply tell the prisoner about it and note their comments relating to same. The broad-ranging absolute power of the governor is deeply concerning and is rife for abuse. By the time a prisoner speaks to a legal advisor and the appropriate letters are drafted to the prison requesting clarification of same, the period of detention in this manner may have expired. And even if it is continuing, the nature of the power afforded becomes incredibly difficult to challenge before the courts. I wish now to move to discuss briefly the experience that I and colleagues in this office have had in dealing and interacting with the prisoners and the prison during this pandemic. It goes without saying that COVID-19 has negatively impacted all aspects of life as we know it, and the reductions in freedoms is something which non-incarcerated citizens have struggled to grapple with. But much like the quote I opened with, let us be judged on how in that environment we have treated our prisoners. In terms of functionality and efficiency, COVID-19 has certainly led to the proceeds of video link consultations to prisons and to courts being significantly improved. The knock-on effect of this has been to assist in reducing the delays and inefficiency that COVID has directly created. It has allowed practitioners to eliminate travel time and time spent going through prison security, and in the court process, far more importantly, it has allowed prisoners to opt for video link rather than face the circumstances of sitting in court cells for prolonged periods, or worse, prison vans parked on main streets on roasting hot days. The manner in which it has been improved and advanced should be a source of pride for all stakeholders involved. I place a full stop there because I genuinely don't want to be seen to be caveating every positive with a however or negative. But however, there is many problems. As practitioners, we know that video links are not for everyone, not for every case, and not for every client, especially for those who are vulnerable. Repeated lockdowns have resulted in walk-in visits, as we would know them, being significantly reduced, which in certain cases is a denial of our clients' access to legal advice while in custody. Legal visits aside, video links are also being used to allow prisoners to communicate with their families, but their use and functionality is infrequent. And whilst I think prisoners could get over not seeing their lawyer face-to-face, for many, especially those vulnerable, seeing their mother on a computer screen is not going to cut the mustard. We've experienced prisoners reporting that they're being denied showers, and the managing of COVID-19 within the prison is to effectively place them on 23-hour lockup. To deny en masse basic prisoners' rights under the heading managing COVID within the prison, and to be commended for it in the media, is galling and should be a worry to us all. Authorised structured activity are an important part of everyday life in the prison, both in assisting in the rehabilitation of prisoners, allowing them to educate and better themselves, and to plan for the all-important life that awaits them after prison. Its benefit in terms of someone's mental health cannot be overstated. However, since March 2019, its presence in our prisons is close to non-existent, and the knock-on effects of this are profound. Young people have gone into custody and been held in quarantine for a 2-week period, even where this might be their first steps into a prison. They're held in quarantine for a 2-week period. They're then released into the general population, and then they might be brought to a court appearance or a Garda station to deal with a subsequent event, and then returned to the prison only to be held in a subsequent 2-week quarantine. This directly leads to them having at times a lack of access to legal visits or family visits and to other basic rights as provided for by the rules to be denied. I don't have a big ending to this 10-minute window, and conclusions have never been my strong point. I would like to say I think the work the IPRT does and continues to do is highly commendable. I think the responsibility for advocating for the enforcement of these rules falls to us all. If the standard is to be achieved in our prisons that our society can be proud of, rather than treat it as some dirty little secret, which applies to those for whom society cares little. Thank you very much.
Thank you very much, Damien, and for that rare insight into the reality of working with people in prison and vindicating their right of access to justice in the current conditions. So thank you very much for the opportunity to hear about that in particular, as well as the other matters you discussed. I'm going to move on now to our next speaker, who is Matthew Kenny, a partner and founder of criminal defence firm O'Sullivan Kenny LLP. In 2013, Matthew was awarded the Public Interest Law Association Gold Medal in recognition of his work in this area, and he has further worked with the ICCL and the IPRT on various projects. So Matthew, we're very much looking forward to hearing your perspective on the prison rules. Thank you.
Thank you very much. Thank you, everyone. And I hope everyone can hear me. I presume I'll be told by somebody if I'm not being understood or heard on Zoom. I just want to talk for about 10 minutes in relation to my experience as a practicing solicitor dealing with one particular issue that I think is a very practical issue. It's my experience as a solicitor acting for remand and sentence prisoners that one of the most stressful issues for prisoners is not, in fact, often their court proceedings or how proceedings end. It may not even be going into custody, having bail denied, bail revoked, or lengthy sentences imposed. Sadly, due to the nature of some repeat offenders, or some people hardened or wishing to give the appearance of being hardened by the justice system as repeat offenders, they often show no emotion, in my experience, to the deprivation of their liberty. And they often can put on quite a front when they're in custody as well. But the one area which I experience quite a high degree, an unusually high degree of emotion and stress from my clients and their family, is the deprivation of family relations during their time on remand or serving a sentence. The need for clients and families to maintain contact during the imprisonment period is a very real one. And it's one that puts quite a lot of pressure on a criminal defence solicitor long after the case may be quite simply over. So I also find this stress is particularly heightened at Christmas time and time of First Holy Communions or confirmation, times when I think the greatest degree of pressure, family pressure, is probably put upon the prisoner for their predicament, for their non-attendance at such an important family occasion as a First Holy Communion for a child, confirmation, or the Christmas holidays. And there's obviously also an added financial pressure on families when a breadwinner is not winning bread, is not at home providing for the family. And there's obviously a financial and emotional strain that is very one-sided, and sadly often the burden falls upon the mother of the children, or in some cases even more sadly the grandmother of the children. This stress and this strain has been particularly evident to me in practice in the last 11 months due to the pandemic and the unprecedented circumstances that we're all dealing with. And I think it's particularly stressful for prisoners. And I agree with Damien, and I'm sure other speakers will comment upon this. I see on a very real and practical level when I deal with the prison officers and the prison staff, both in communications by email and in person on the times during the break in lockdown in the last 11 months when I was back in the prisons visiting clients in person. I see the very real and genuine efforts that on the ground prison officers are making to do their absolute best for the prisoners and to ensure an enjoyable working environment and an enjoyable experience for families who did get into visit for the limited period that visits were back on during the last 11 months. But limitations or problems with the communication between prisoners and their family, I think is especially prevalent or especially stressful in my experience for prisoners who have pre-teen children between the ages of 4 and 11. As a parent myself of a 9-year-old during COVID, I've seen from my own experience that there's a particular age upon which a child will see their parent as their hero, with their parent as a very important source of education, interaction. They look up towards you. And I think it's pretty clear that that tends to be a lessening effect the older a child gets, and as they move towards their teenage years, they obviously have less interest in their parents as they go out into the world themselves as young teenagers. Just in relation to the rules that govern this important issue, Rule 43 of the Prison Rules 2007, as we heard in the opening remarks, the prison rules were long overdue for reform from the 1947 rules, were reformed in 2007. And I agree that they, as all rules should be, and as all laws should be, they're being well monitored by the IPRT and other advocates, and they're probably due for reform in certain areas. And possibly this is an area that is due for reform. Rule 43 allows for a prisoner to send and receive post. Subject to the provisions of these rules, a prisoner shall be entitled to send letters to his or her family or friends and to receive as many letters as are sent to him or his family or friends. Now, I'm not going to quote the rules verbatim, but if anybody is at a computer and wants to look them up as I speak, feel free to do so. But Rule 43 allows for a prisoner to send and receive ordinary posts. And there's a difference between Rule 43 and Rule 44. Rule 44 is correspondence to and from the prisoner and solicitor and or certain other designated people such as the parole board, and that attaches a certain privilege that Rule 43 doesn't get, and a certain protection that Rule 43 doesn't get in relation to censorship and review by the prison authorities prior to its onward transmission and delivery to the prisoner, or out from the prison to the recipient. Now, since the passing of the 2007 rules, and I checked again this morning, as rules are often amended, and the prison rules 2007 have been amended in certain areas, Rule 43, 44 and 45, which I'll discuss in the next 5 or 6 minutes, hasn't been amended in that period of time. It's my experience that, based only on complaints, of course, that I can speak to made by my clients and passed on by me to the governor of the relevant prison, that prison family post in and out, so from the prisoner to the family and from the family into the prison, suffers from long delays to the point where, when it's finally received by the prisoner, the event that the prisoner is missing is long gone, in particular the Christmas period. Now, these delays are notorious, according to my clients in prison, amongst the prison population. They're well aware of them themselves, and the law of unintended consequences, in my experience, has resulted in particular shortly before the Christmas holidays last year, at the end of a very stressful year, a year upon which a huge amount of prisoners were denied but for public health reasons, regular visits and in-person visits with their family, and in particular their young children. It reached a fairly critical point where I received numerous phone calls from my clients asking me to circumvent the prison rules and allow for their family members to deliver Christmas cards, handwritten Christmas cards, school-written Christmas cards by their children into my office and deliver them through my office's post to the prisoner. Now, clearly, I can't send a document or a family letter or Christmas card through my solicitor post to the prisoner as it's Rule 44, because it's not. Now, what we decided to do, given the volume of phone calls and requests by our clients and family members, and the genuine upset of our family members, was we agreed in certain circumstances to receive these into our office and write a very clear letter to the governor that this was not Rule 44, that what was within our envelope was quite clearly Rule 43. It was private family correspondence, and we set out why we were doing this and why we were concerned by the delays, and would they look into it, but in the short term, would they ensure a speedy delivery of a Christmas card pre-Christmas, so that it got actually some benefit towards the client, towards the father of the child who had sent and written these sorts of Christmas cards. So clearly it's not appropriate, and we wouldn't have sent it by Rule 44, we sent it by Rule 43. And thankfully it was delivered. And I think that's a very obvious example of the prison taking a very practical approach to what was a very real problem, and possibly just a very genuine resource-based problem. So if we look at Rule 43 and how it might have a tension with Rule 45, the prison has certain abilities to censor prison material. So I'd invite anyone to have a look at Rule 45. It's quite lengthy. I'm not going to read through it all, but it is clearly a rule that allows for the prison authorities to censor, to withhold, and to delay the transmission of private correspondence from a prisoner to their family or friends, or from family back into the prisoner. Just briefly, in summary, as I don't want to go beyond my 10 minutes, if we look at Rule 43 and if we think about the need and the importance of family relations and correspondence and the exchange of cards, letters, drawings, artwork by children to their fathers in prison, and I presume complimentary remarks, as any parent would, on that terrible artwork from the father back to their child, how important that is for all of us. It's equally important to prisoners, even more so this year with the denial and the restriction on visits. But of course, these rights are not absolute. And of course, the prison has to have a certain margin of appreciation and discretion in how it might receive and deliver post, and how it might allow post to be sent from the prison out. So the rules tend to be restricted, or rather are restricted. And if we look at why they're restricted, or how we might advise clients as to whether or not they can challenge or any of these sorts of restrictions, the rules arise from our constitution, they arise from the European Convention of Human Rights, and they've been upheld, and they have been tested, and they have been discussed and reviewed in Superior Court judgments. And just in summary, we have the constitutional rights. We have the right to, well, I think the most important right, and perhaps the right that's not being used enough, as it's only a relatively new right, is the voice of the child. And I would suggest that as practitioners, we might rely upon the right and the voice of a child, and what's in the best interest of the child, if we are to take any sort of a test case to the restriction on post in or out of the prison from a family, from a child to its father. I think we ought to look at what is in the best interest of the child, and whether the restrictions upon post are being dealt with properly by the prison, or whether it's a resource issue, and if it's a resource issue, whether it's been given enough resources, and why it's not being given enough resources. If we look at the European Convention rights, the most recent guidance note from the ECHR suggests that the rules that govern prison posts throughout those countries that attract convention rights, they ought to be clearly set out in prison rules. They do appear to be clearly set out in Rules 43 and 45. Family and prisoners ought to be able to understand them, and the limitations on prisoner post and censorship of the post ought to be for a legitimate aim. And if we look at 43 and 45, it does in the face of it appear to suggest that things such as prison security and good order and the prevention of crime do give them a discretion, but it's not a blanket discretion. And it does appear that accidentally, perhaps, there is a practice in the prison, according to complaints by my client prisoners, that every piece of post is being stopped, is being reviewed, and is being delayed in its onward transmission in or out of the prison. And that wouldn't, in my view, necessarily meet a rigorous examination. Sorry, I'm going to just, I'll be done in 30 seconds. And just finally, we have had this discussed in the Carney case. So it is settled law in our courts, in the High Court and the Supreme Court, that prisoner post does attract rights. It does attract the protection of the courts, and Justice Lee Rafferty also upheld this right in the SF and TG case. So the courts will intervene if it's satisfied that the prevention or that the interference by the prison authorities go beyond what is necessary, and if they are not upholding or maintaining family relations in a way that is arbitrary or capricious, the courts will afford protection. Thank you.
Thank you very much, Matthew, and again for that incredibly practical insight into the realities of your work and kind of ingenious mechanisms to try and do your duty. So thank you very much for that, and sorry to be pressing in the interest of time. Thank you. We're going to hear now from David Perry, who's a practicing barrister. We've had the great opportunity to hear from two practicing solicitors, and you'll have seen the wonderful insights into the day-to-day reality of their work, especially during COVID. And we're going to get a perspective from the bar now, which gives me a very nice opportunity to thank the co-hosts for today's event, the Irish Criminal Bar Association, for their support for this event, and indeed their long-standing support for these prison law seminars. So our very sincere thanks to our friends in the Irish Criminal Bar Association. And also just a quick reminder, do feel free to keep your questions coming in on the Q&A box. Thank you. We'll be moving towards Q&A shortly. So it's my great pleasure to welcome David Perry, a practicing barrister who practices in the areas of prison, human rights and criminal law, previously a judicial assistant at the European Court of Human Rights, and also a lecturer at King's Inns. and indeed a member of IPRT. So David, we're delighted to hear from you, please.
Thank you very much, Mary, and hopefully you can all see those slides I've just put up there. I'm sure someone will tell me if they're not up or you can't hear me. And really, I should just start by thanking the Irish Penal Reform Trust for inviting me to speak at this event, for organising the seminar as a whole. Prison law is a constantly evolving field, raises all kinds of complex issues, and there's real value to having prison law seminars like this one, both to keep up to date on the law and also to look at how it might be improved, to start conversations on those issues. So in terms of what I'm going to talk about, I've really been asked to highlight a number of different ways in which prisoners can rely on the prison rules in claims before the courts to defend their rights. And I'm going to highlight 3 ways in particular in which that might be done. So first of all, I'll look at the extent to which the rules can be used to challenge the legality of conditions that the prisoner might face. I'll go on to talk about the ability to use the rules to challenge and reverse the outcome of unfair disciplinary proceedings. And then finally, I'll look at the ability to use the rules as a means of overturning decisions to segregate or isolate a prisoner. Now, you may wonder, why am I looking at those areas in particular? Well, I'm doing it in part because there are a number of recent cases that make it clear that those are ways in which the prison rules can be successfully litigated by prisoners. And I'll try to refer to some of those as I go. I'm also highlighting those areas because, in my view, those are areas in which the prison rules add in a very significant way to what we might think of as being a prisoner's existing legal arsenal. And the rules give very clear and specific rights in those 3 areas that are not really replicated in the more general rights that the prisoner has under the Constitution, under the Convention, or under the common law. And in essence, the prison rules mean that a prisoner can advance a clear and enforceable claim in those areas. Now, those are all positives. I will be ending, though, by striking the same sort of notes by way of caveat that Damien did when he addressed you. There are limits to what can be achieved by litigating the prison rules. They're very important to be aware of, and I'll conclude by addressing some of those. So let me talk first of all about the capacity to use the rules to challenge the legality of conditions that a prisoner is exposed to. And part 3 of the rules is particularly significant here. It sets out certain basic conditions that have to be provided to all prisoners. Those requirements are often quite specific. I've just highlighted some examples there on the slide, but Rule 23, for example, requires that each prisoner is provided with a sufficient quantity of wholesome, nutritious food and drink each day. That must be properly prepared, well presented, reasonably varied. Rule 27 provides an entitlement to a minimum 2 hours out of the cell each day, with an opportunity for meaningful human contact during that period of time. And then Rule 32 requires that a prisoner be given not less than 1 hour of exercise in the open air each day. It's worth just saying for completeness that there are also other relevant provisions outside of Part 3 that touch on conditions. For example, there are provisions dealing with education and with medical treatment that feature in other provisions of the rules. So in those ways, the rules carve out an entitlement to certain minimum conditions, and it's possible for a prisoner to seek to enforce those entitlements in court. There are a number of cases in which those kinds of arguments have been made, and I've highlighted some of them on the slide. I just want to focus in on one recent case in particular, which is a case called Whelan and the Governor of Mountjoy Prison. And that's a case where the plaintiff was provided with an hour of exercise each day, but the issue was that that took place in a confined area which was entirely walled and roofed by steel plating, although there was a sort of steel mesh through which light and air could get through into that area. And he argued that that meant that he was not getting exercise in the open air as required by Rule 32. Now, Ms. Justice Murphy agreed with that argument. She was of the view that the exercise area here was not an open air facility, and she granted a declaration that the prison authorities had failed in their duties under Rule 32 of the rules as a result. So that's one way in which the rules can be relied upon as a basis for legal challenges by prisoners. and another is in relation to disciplinary inquiries. So the position is that the schedule to the prison rules sets out disciplinary offences for which a prisoner can be tried and can be sanctioned by a governor. However, Rule 67 sets out a specific procedure that must be followed before any sanction can actually be imposed. So, for example, a prisoner has to be given notice in writing of the alleged disciplinary offence. That notice must usually be provided at least a day before the inquiry takes place. And during the inquiry itself, the prisoner is entitled to examine the evidence against him or her, examine any witnesses, and call or give evidence on his or her own behalf. And if that procedure under Rule 67 is not followed, the prisoner may seek to overturn the result of the inquiry. And there's a number of recent cases in which that has been successfully done. I'm just going to look at two of those quite briefly. The first is a case called Kenny and the Governor of Portlaoise Prison. And that's a case in which the plaintiff was found guilty of receiving contraband during a visit from his partner. Now, the assistant governor who conducted the inquiry had reached that decision after viewing CCTV footage, but refused to show that footage to the plaintiff. And in the High Court, Ms. Justice Ní Raftery held that under Rule 67, the plaintiff was entitled to view the footage upon which the governor was proposing to base his decision, and was entitled to have the opportunity to comment on that footage with a view to trying to persuade the governor that nothing untoward was happening. Ms. Justice Ní Raftery accepted that that might well have made no difference at all to the outcome of the disciplinary proceedings. It might have been that nothing the plaintiff could have said would have changed the mind of the assistant governor on the case. But she said that that didn't affect the basic obligation on the prison authorities to show the core evidence to the plaintiff. And given that there was that breach of Rule 67, Ms. Justice Ní Raftery quashed the outcome of the inquiry. Similar conclusion was reached more recently in a case called Dublin and the Governor of Arbor Hill Prison. And there, the High Court overturned the result of a disciplinary hearing where the plaintiff was found guilty based on transcripts of phone calls he had allegedly made from the prison, but he was not actually allowed to view those transcripts. Finally then, let me just deal with how the prison rules can be used to challenge decisions on the segregation or the isolation of prisoners. The prison rules sets out various situations in which a prisoner can be segregated from the rest of the general population. Damien already touched on Rule 62, which allows a prisoner to be segregated for the maintenance of good order and security. Rule 63 as well, for example, allows a prisoner to be separated for his or her own personal safety. Each of those rules sets down certain conditions that need to be fulfilled and procedures that need to be followed before a prisoner can be segregated. So, for example, with Rule 62, the governor must have reasonable grounds to believe that allowing the prisoner to remain in the general regime would result in a significant threat to the maintenance of good order or safe or secure custody. There's then a particular procedure that needs to be followed as well. And the governor, for example, needs to notify the prisoner of the reasons why Rule 62 has been invoked. And there are certain obligations then in terms of monitoring the decision after that. The decision to segregate a prisoner can be and has been challenged on the basis that those rules have not been complied with. And if you look at the case law, there's really two types of challenge that have tended to come before the courts in recent years. One sort of challenge, it involves a situation where the prisoner is segregated from the rest of the population, but none of the rules have actually been properly invoked to provide a legal justification or legal basis for that segregation. And that was the situation, for example, in Dundon and the Governor of Cloverhill Prison, and also in Dumbrell and the Governor of the Midlands Prison, both cases where the plaintiffs successfully challenged the decision to segregate them from the population. And the courts in those cases made it clear that it's unlawful to segregate a prisoner, whether expressly invoking or following the rules. Another sort of challenge, though, is where, even though the rules have been invoked, the actual procedures set down in the rules have not been followed. And Paget and the Governor of the Midlands Prison is an example of that sort of case. And that's a case where the plaintiff was successful in his claim that Rule 62 had been breached because he wasn't provided with the sort of notification or reasons why Rule 62 had been invoked as required under Rule 62, paragraph 5. So those are all areas in which prisoners have a proven track record of success in relying on the prison rules to vindicate their rights. And there are certainly positives, as I said, but what's really important is to appreciate that there are really limits to what can be achieved by litigating the prison rules, relying on the prison rules before courts, beyond the sort of things that have been considered here. There are a couple of reasons for that. And I think it's probably more productive if I summarize the reasons for those limitations as opposed to going through what all those possible limitations might be. First reason for the limited usefulness of the prison rules in litigating claims beyond what I've considered are limits in terms of what the rules actually provide. So part of the strength of the rules is that they provide specific rights in particular areas, but it's also a limitation because you can obviously only enforce what you specifically have under the rules. And there are notable omissions in terms of what is not provided for in the rules. So, for example, insofar as the rules deal with privacy for prisoners, it tends to be along the lines of privacy in being transported to and from the prison, separation of male and female prisoners, and things along those lines. Part 3, dealing with conditions of detention, doesn't really delve into any sort of detail in terms of privacy rights that be afforded in terms of accommodation of prisoners and matters of that nature. There is no specific provision in terms of individual personal space, which might be seen as a striking omission, given that's a part of the CPT's guidance in terms of prison standards. It's also, as Damien said, the case that the prison rules do not specifically outlaw the practice of slopping out. The second major issue that limits the usefulness of litigating prison rules is something that Damien has already dealt with, and I'll just touch back on it again. I'll re-emphasize his comments. Many of the provisions of the prison rules are couched in very discretionary terms. So some are quite specific. They say that a governor shall do X, Y, Z, but other provisions are couched in far more general terms. They say that a governor may do something if satisfied that such and such is the case, or insofar as something is reasonable. The general stance that has been taken by the courts is that the exercise of that discretion can only really be reviewed if it was capricious, arbitrary, or unjust, which, suffice to say, is a very high standard for a prisoner to try to meet in terms of a challenge to the exercise of that discretion. So there is a lot of stuff provided for under the rules which you're really not going to succeed in challenging. And the final thing then to say is just that the rules are open to amendment, something that will be discussed later on in more detail during this session, but the rights that you have can certainly be amended and taken away. And indeed, Molly touched on that in terms of the amendments that were made in July 2020, which provide for open-ended restriction in terms of the right to exercise. So I see Mary is politely reminding me that my time is now well up. And so I'll end there and just thank you very much for listening.
Thank you very much indeed, David, for such a clear and helpful overview of some central aspects of the prison rules, and that reminder that if you don't get the prison rules right, then you can be leaving yourself open for various problems down the line. So a very important reminder. Thank you very much for your contributions. We're going to take a 5-minute break now, and we'll resume again with the second half of our session in about 5 minutes or so. So look forward to seeing you then. Hello again, everybody. I hope you got a chance at least to stretch and maybe get a glass of water or something. We're going to move now into the second part of our event. And following on from our previous discussion about the ways in which the rules have been used, we're going to explore a little bit more about how the prison rules might be used beyond litigation and how we may reform the process by which the prison rules are drafted. And then thinking more positively and more expansively, what might we want to include in a new set of prison rules that would be fit for current practice and hopefully aspire to be the best set of rules that is absolutely possible. And in that regard, we're going to hear from our first speaker, who is Patricia Gilheaney, the Chief Inspector from the Office of the Inspector of Prisons. And it's a very great privilege to welcome her to today's event. Patricia was appointed Inspector of Prisons in May 2018, having previously held a number of senior positions, including CEO of the Mental Health Commission. And her interest in human rights stems from her background as a psychiatric and general nurse. Her postgraduate qualifications are extensive and was most recently appointed an adjunct professor at the University of Limerick School of Law in May 2020. Patricia, we're very much looking forward to hearing from you. The floor is yours.
Thank you. Thank you very much, Mary. Good afternoon, everybody. And I would firstly like to thank the Irish Penal Reform Trust for inviting me today to participate in today's event. So thank you for the opportunity. This is the first in a series of prison law seminars, and I certainly look forward to attending all future events. I would also like to take the opportunity to congratulate the IPRT on the launch today of the 2020 edition of Know Your Rights, an invaluable 80-page document that clearly spells out the rights of prisoners. Rule 13 of the Prison Rules in Ireland, the 2007 to 2020, requires that, and I quote, each prisoner shall, upon admission to prison, be given an explanatory booklet outlining his or her entitlements, obligations and privileges under these rules. The provision of Know Your Rights to every person in prison in Ireland will go a long way to ensuring compliance with this rule. I've been invited to address the topic of the role and importance of the prison rules in maintaining prison standards and guiding the work of the Office of the Inspector of Prisons, and I'm pleased to do so. International best practice requires a system of independent monitoring so that transparency and accountability of a prison system can be achieved. This requirement is covered in the body of principles for the protection of all persons under any form of detention or imprisonment. In the context of a global pandemic, scrutiny and oversight of additional restrictive measures in society in general, and particularly in prisons, is an essential human rights protective measure. The objective of inspection is outlined in other international standards and rules, such as Rule 83.2 of the United Nations Standard Minimal Rules for the Treatment of Prisoners, as we commonly refer to as the Mandela Rules. And that states that inspections shall be to ensure that prisons are managed in accordance with existing laws, regulations, policies and procedures, with a view to bringing about the objective of penal and correction services, and that the rights of prisoners are protected. And indeed, the strengthening of Part 6 of the revised European prison rules in relation to inspection and monitoring is welcome, in particular as it provides that no prisoner or prison member of staff shall be sanctioned for providing information to monitoring bodies. Reports by national and international NGOs, the findings of the Committee for the Prevention of Torture, Inhuman and Degrading Treatment, and various decisions of the European Court of Human Rights show that even in countries with well-developed and relatively transparent prison systems, independent monitoring of conditions of detention and treatment of prisoners is essential to prevent inhuman and unjust treatment of prisoners and to enhance the quality of detention and of prison management. In 2006, the Council of Europe, in its commentary of Recommendation 2 of the Committee of Ministers to Member States on the European Prison Rules, stated that the establishment of independent national monitoring bodies, in addition to a government-run inspectorate, should not be seen as an expression of distrust of the quality of governmental control, but as an essential guarantee for the prevention of maltreatment of prisoners. Therefore, I suggest it could be positive that an independent inspectorate is vital in ensuring that prisoners' rights are not violated. Our mission in the Office of the Inspector of Prisons is supporting excellence in both delivery and outcomes in Ireland's prisons through an independent programme of inspections and investigations. This year, commencing next week, we will undertake a systematic programme of inspections of Ireland's prisons, which is, in our view, independent, transparent, improvement and prevention focused. Last year, we published a framework for the inspection of prisons in Ireland, which sets out how we will conduct our inspections. That framework is informed by national legislation, both primary and secondary, relating to prisons and prisoners' rights. It is accepted that the requirements of the rule of law specify a minimum threshold for desirable behaviour. And as Lon Fuller postulated on the moral value and the rule of law, I quote, "It is not the business of law to prescribe for excellence, but rather to ensure a minimum standard," which you refer to as procedural morality. However, it is important to recognise that the rule of law requires that certain fundamental individual rights be constitutionally guaranteed and protected in practice. So the prison rules are important in stating what the minimum standards that prisoners can expect are. However, this can be difficult, if not impossible, to ascertain due to the significant caveats that are woven through many of the rules. Therefore, a review of the prison rules is timely and, in our view, must involve a wide range of stakeholders, including civil society. As already stated, our role is not merely to assess compliance with minimum standards, i.e. the prison rules, as we see ourselves as human rights focused, supporting excellence in both delivery and outcomes for prisoners. Therefore, in addition to domestic legal requirements, there's a range of relevant international human rights obligations which Ireland is party to, and standards which inform the Inspectorate's approach to inspection work. And these include, but aren't limited to, the following international treaties which Ireland has ratified: the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the European Convention for the Protection of Human Rights and Fundamental Freedoms, the United Nations Convention on the Rights of Persons with Disabilities, the United Nations Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, the European Convention for the Prevention of Torture and Inhuman or Degrading Treatment or Punishment. But particularly relevant to the work of the Inspectorate are three sets of authoritative standards dealing with the treatment of prisoners that are not legally binding, but are accepted as best practice. The European Prison Rules 2006 as revised in 2019, the Mandela Rules 2015, and the United Nations Rules for the Treatment of Women Prisoners and Non-Custodial Measures for Women Offenders, commonly referred to as the Bangkok Rules. Also particularly relevant to our work is the European Committee for the Prevention of Torture and Inhuman and Degrading Treatment standards, their country reports, and also their annual reports. We must also bear in mind the optional protocol with the Committee Against Torture was adopted by the UN Assembly in 2002 and entered into force in 2006. Although the OPCAT establishes a system of regular visits to all places of detention, it is disappointing that Ireland has not yet ratified. However, we are informed that that is in the programme for government and that the Department of Justice and other government departments are working towards ratification before the year end, and we certainly welcome that. Implementation of ongoing monitoring component of inspections will have equal importance to on-site inspection visits. Historically, inspections were carried out, inspection reports published, and there it ended. If inspections and inspectorate bodies are going to have a preventative role, monitoring has to be a key integral component in any process, and we will grasp and embrace that. The inspection framework is based on 5 focus areas: safety and security, respect and dignity, health and well-being, rehabilitation, development and resettlement. In our upcoming inspections, we will be including a focus on the Prison Amendment Rules 2020. The amendment involved the insertion of an additional Rule 32A that allows for further restrictions within the context of infectious diseases in prisons to suspend the entitlement to physical recreation, exercise or training under Rule 32, and an additional Rule 36A that allows for the suspension of the entitlement to visits under Rule 36, or restrict or modify the frequency, duration and arrangements of such visits. It is of concern to us that there are no sunset clauses in these rules. It is also of concern that these rules were brought into practice in a very quiet manner with very few interested stakeholders aware of their existence, including the Inspectorate of Prisons. As the independent lens through which the Minister and civil society sees into prisons, we will play our role in terms of oversight and scrutiny and the prevention of human rights abuses of individuals in custody in prisons in Ireland when we commence our first inspection next week. It is our intention, and we have planned, to carry out COVID thematic inspections of all prisons in Ireland before the third quarter of this year and provide a report to the Minister on each of those inspections before the third quarter this year. We will be independent, transparent, and we will fairly report on life in prison for prisoners and those who work within prisons. We have articulated our concerns over many years regarding the prisoner complaint system. A fully functioning complaint system is an essential requirement, particularly in settings where deprivation of liberty is in train. Unfortunately, the prisoner complaint system continues to remain unfit for purpose, although this has been raised in our annual reports since 2016. The Irish Prison Service needs to be appropriately resourced to ensure that that situation is remedied. Another example of a rule that is of particular concern to us is Rule 57, which provides for a prisoner to meet with the office of the Minister, an officer of the Minister. And we have discovered that at times, the person within the Irish Prison Service who has been a decision maker in a certain matter is then the person that is assigned to meet with the prisoner who is requested to meet an officer of the Minister. So in essence, the person to whom an appeal is being made is actually the original decision maker. It is unlikely that that was the intent of Rule 57 when it was developed. So in summary, we welcome the proposed revision of the Irish prison rules, and the inspection framework that we have established will not solely confine itself to the prison rules in Ireland, but will rely on international best practice, guidance, and the European prison rules to guide us in our assessment of the Irish prison system. Thank you.
Patricia, thank you very much for your insights and also for that newsflash about the COVID-related inspections. We appreciate your time. Thank you very much. We're going to move on now to hear from John Farrelly for a different perspective from a related, certainly very much related, but different domain on the question of regulations and procedures. John was appointed CEO of the Mental Health Commission in October 2018, and before that he held a number of senior roles in the health and social sectors. He's a graduate of the Royal College of Surgeons, King's Inns, LSE, the Harvard Kennedy School, and he was recently conferred as a fellow of the RCSI in December 2020. So John, we're very much looking forward to hearing your insights from a related field. Thank you.
Thank you. I hope you can hear me. I was sitting here worrying whether I'd be on mute or not. Well, first of all, thank you. I'm delighted to speak to everyone, and it's good to see so many people attending. I'm going to tell you a little bit about what the Commission does. We're the regulator of mental health services in Ireland. And just to let you know that a centre where people are treated, it's a hospital and people are patients. And it's an inpatient facility for the care and treatment of persons suffering from mental illness. It is radically different from a prison, and I've been in both. And in fact, I've worked in different secure units in England. And I know we have Dundrum, and again, Dundrum is even radically different from a prison. I've been on some of the landings in the prison where I've seen people who are mentally ill. So just to be clear on that, we're regulating hospitals and health centres where there are patients who are mentally ill. Now, a number of those people are also detained against their will and involuntary detained. And those to me are key people. There's a couple of thousand of those people are detained. And there's very strong rules around that about how someone can be detained, and I'll come back to that. So we have, I just want to give you a sense of listening today and the legalistic mechanisms and a lot of talk about the legal discourse. Look, I'm not a big into the legal discourse. I'm into the human discourse, a rights-based approach, that there's minimal rules to protect people. But actually what really pushes things on is quality, and that's where healthcare comes from. So you have basic conditions and regulations, etc. But the real quality places, the bar is raised. I'm not sure if that's the case in prisons, but most closed institution over the years, the good one, the bar was raised actually by the staff and the people who work there, without the need for necessarily rules. So we have a booklet, and it's known as the Blue Book, and it's Knowing Your Rights is actually the name of it. And the idea is to help people to be more involved in their care and treatment and to feel more empowered. And the booklet answers a number of questions about mental health services, admission to hospital, human rights, receiving treatment, consent to treatment, and indeed having a tribunal, which I'll talk about. I mean, we're reviewing the Service User Guide. It's the Service User Guide, or the Blue Book in the Mental Health Act, and it literally is blue, and it's a book. And we're changing that now because there is something about it that it looks kind of penal in nature. Because of course we're all coming from the basis of these big institutions, and don't forget that Ireland had more people in mental health and psychiatric institutions, you know, going from the 1850s onwards, and it wasn't really because of mental illness, it was because of poverty and because people were actually criminalized, poor people. And for many people, and unfortunately I've still seen this in this day and age, for many people being in hospital is nicer than being at home. You don't see it as much these days, but you see it for some people. So this booklet, we have it available in as many languages as possible. I think it's 7 now at the moment. And we're reviewing that to break it down as well into different ways so that it's relevant to, because people don't want to read the whole lot. They only want to read what's relevant to them. So essentially, if you're brought into hospital against your will, involuntarily detained, there's rules and laws around that. And we make sure that mental health tribunals occur within 20 days of any admission or order detaining a person. This is all based under the 2001 Act. Before that, there was the 1945 Act, which was pretty much, you know, it was very, very relatively basic, but for its time, it was quite good. Funny enough, when we were changing the 201 Act, there was a lot of people had a lot of reservations about it. You know, would it be strict enough to protect people, etc., etc. It's turned out it's very good. We're reviewing the Act again to push on again. There'll be a new Act coming out soon, next year. But you know what? My experience is you can have laws and acts, etc., but it's about the human beings who are involved pushing forward in terms of the quality. So, but if you are brought in against your will, and it must be on very strict grounds that you have a mental disorder, and that in doing that you need to be brought in for treatment because you're a risk to yourself and an immediate risk. And when someone comes in, within 21 days, we set up a tribunal which is independent, which is a chairperson, a barrister, a solicitor, a consultant psychiatrist, and a lay person, all independent, who review this, making sure the mechanisms are correct, and also that medically one needs to be there. In addition, we appoint a legal representative to act for the patient, and then that's funded by us, and an independent consultant psychiatrist to review, again also funded by legal aid from the Commission. The tribunal takes place in the mental health units where the patient is detained. And I actually think it's a very good system for vindicating people's rights. We then also have rules around codes and rules. In the Act, we're allowed to set codes and rules around electroconvulsive therapy and governing the use of seclusion and mechanical means of bodily restraint. Again, these are going to change in the Act because in our current Act, it kind of gives the sense they're a sort of a therapeutic endeavour. They're necessary at times to make sure that people can get the treatment they want. But I'm fairly clear they're not therapeutic. In fact, look, if someone tried to hold me down or lock me in a room, I don't think they get a therapeutic response from me. So you often get these things masked in a particular language, but which I actually don't agree. And that's why we have the rules, and the Commission have the rules. And it's something we're pushing for. We're going out on a public consultation next year around some of these rules, so that they're absolutely fair. They vindicate people's rights. And I also want to talk in terms of the staff, because we want to get the staff's view. See, mental health services, there's an awful lot of psychiatric nurses, doctors, OTs, psychologists, social workers, all highly, highly trained people, very different to the prison environment, very different, highly trained people who know what they're doing and who want to push on and make things different. Now we go out and we find things and there's issues, like even in terms of the restraint and the seclusion. You know, to be honest with you, if we had the right buildings, well designed, and the right amount of staff, you'd probably see that going down. We published a report today on the physical environment, and we found that there's still a significant numbers of buildings where you put someone in, they're slightly overcrowded because we don't have enough of them. And it's not an environment that's conducive to someone who's very, very unwell. Now we're changing that, and there's a lot of new buildings. But I suppose what I wanted to get to was, in mental health, there's a collaborative approach. We're the regulator, we'll go in, if it's not right. The first prosecution happened about 1.5 years ago, where we weren't happy with the seclusion and we prosecuted the HSE. But behind that, there fundamentally is an air of compassion and care. And when you can get the place right, you can touch that. But that can get run over if there's overcrowding, if the building isn't right, if there isn't enough staff. So we have the commission. The commission has the power to develop these codes and indeed to act if they're breached. And by and large, they are adhered to. By and large, people really try and vindicate and respect people's rights. The problem is that this involuntary detention, seclusion, etc., where it's needed. So, for example, Dundrum is due for registration, and we're looking at that and working with the HSE to be crystal clear that this is a therapeutic environment for patients. It's not a prison, and it's not for prisoners. So holding that line, people who may be prisoners, who may become unwell, who may develop a mental illness and need treatment in a hospital, may go to Dundrum, but we're trying to set the rules around, notwithstanding their security needs and all that, absolutely, but setting the rules around health and the therapeutics. I suppose we will be reviewing them this year. The quality framework we do, the regulations we have, we adhere to them. And look, to be honest with you, there is a fair bit of legal procedure in the background, particularly around the tribunals, but really is about gathering a group of people, not creating a polarization, but understanding there's a group of people here who have to implement the law, who have to create healthcare, and how do we create the best. Finally, I was previously the Deputy Chief Inspector in HICWA, where I brought in the regulation for nursing homes after Lees Cross. I'm finding as I'm getting older, no one remembers Lees Cross, but it was where older people were treated very, very badly. I was also the charities regulator. And I definitely find that it's all about transparency, being transparent, being open. I know that's a challenge in the prison where, there are a significant number of people who are dangerous and who've been convicted of serious crimes. But so how do you create that balance for, a majority of a population when you have, people who are not per se typical? It's very, very hard. I think what we're doing in terms of knowing your rights, what you're doing is a good idea. I would have thought the state would probably have had to do that anyway, legally. If not, it's probably something we need to think about. But the idea of transparency and good conditions. I've walked the landing where people with mental illness have been, and there is no way that people with mental illness can be treated there. So look, thank you. Thanks a lot, and sure, happy for a few questions later.
Thanks very much, John, and particular thanks for your comment about the public consultation process that you're going to have in respect of your own regulations. So that's very interesting to note. And we're going to move on now to our final speaker for today, and it's a very great pleasure indeed to welcome Professor Dirk van Zyl-Smit, who is Emeritus Professor of Comparative and International Penal Law at the University of Nottingham, as well as Emeritus Professor of Criminology at the University of Cape Town. He's had senior academic roles throughout his career at a number of universities, and those of you who work in the area of prison law and penology will be very well versed in Dirk's amazing canon. He's also actively involved in prison reform and has been an expert advisor to the Council of Europe on the new European prison rules, and we're really excited to hear about those today, Dirk. And he's also the chair of the board of Penal Reform International. So Dirk, thank you so much for joining us and taking the time, and we're very much looking forward to hearing your insights.
Mary, thank you for that splendid introduction. And thank you for inviting me to this whole event. It's been really interesting to, and I suspect I'm one of the few outsiders here, to look at what you're doing and what you're trying to do and what you're trying to change. And I must admit, I have one very radical suggestion, which unfortunately I can't develop, but perhaps when we come to questions. And that is, there are a lot of very interesting things in your prison rules, but why are they not in the Prisons Act itself? If one looks across Europe at what most countries have, if you look indeed to the Canadian or the South African legislation, I would say at least half to 3/4 of what's in your prison rules are in the Act itself. And there are very basic, and the reason is simple, that what you have in your rules deals with very basic human rights, and those should be specified. And as the lawyers amongst you would know, in some countries this is compulsory for constitutional reasons, should be specified in primary legislation. So you're asking, how do you get more shells into what the law says? Well, maybe you should look at moving it into the primary legislation. There are a lot of shells in the European prison rules, and indeed, it's not my it's not my theme this evening to talk about that. What I am going to do, however, is talk about the changes that have been brought about by amendments to the 2006 European prison rules. These amendments took a while to get through the system. They were finally adopted by the Committee of Ministers in the middle of last year. Now, the first question we should ask ourselves is, why was it necessary to amend the 2006 European prison rules? Because when the 2006 prison rules were introduced, and I was fortunate enough to be one of the advisors on that too, we did not expect them to have the influence that they've had. Since 2006, the European prison rules have been quoted, I would guess, about 1,000 times by I mean that literally, by the European Court of Human Rights. There's been a wonderful interaction with the Committee for the Prevention of Torture, the CPT. There have been specialist developments by the Penological Council of the Council of Europe, which has come up with new rules dealing with, for example, with foreigners, dealing with children of imprisoned parents. So why was it necessary to revise the 2006 European prison rules at all? The reason it's not, the very last European prison rule, number 108, says they should be updated regularly, but all European rules say that, and in fact, very few of them are updated regularly. Now, what was going on is that there were winds of change. Some of these have been mentioned already. In 2006, we had OPCAT, the optional protocol to the Convention Against Torture entering into force. In 2010, this is at the UN level, we had the Bangkok rules, which for the first time really brought out the how women prisoners should be treated. And in 2015, the very venerable 1955 UN Standard Minimum Rules on the Treatment of Prisons was amended after more than, well more than 50 years. And also, and I think this is important for at least some of the changes, there have been advances in science, which have led us to say that some of the old rules were simply not good enough anymore. But so those were the international developments. In Europe, there were also developments. The CPT, of which I'm a great admirer, had taken its lead, particularly in the area of solitary confinement, and it had said we should go a lot further than the European prison rules do. The 2006 European prison rules say almost nothing about segregation or solitary confinement, and they came up with a very good idea that you should have as you have, different rules dealing with different types of separation, and that these should be spelt out in some detail. But there was a problem, and the problem was this, that the success of the 2006 European prison rules made them, in a sense, harder to amend. In 2006, or before that, 3, 4, and 5, when we were talking to the different countries about the rules, they tended to say, oh, well, this is a vague standard, it's soft law, not to be taken seriously. And it took a while to even persuade the Council of Europe, for the Penological Council, to persuade the Council of Europe as a whole that the rules should be amended. And in the end, they agreed to amend them in 8 areas, and 8 areas only. So if there's a rule in another area that you don't like, I can say the reason why it wasn't amended is not that we didn't think about it, but that we were limited to amendments in these 8 areas which you see in front of you. Now, given the time constraints, I'll deal separately. I won't read through them all now, and I'll keep separation and solitary confinement for last, because I think it really raises the most interesting and difficult questions in all these amendments. But let me go through these so that you can see what questions were raised and why they were raised. The first one was, the first one I'm going to deal with was the rule relating to women. There was relatively little about women in the 2006 European prison rules. And when it came around to amending them, there was a problem. I've mentioned that the UN has the Bangkok rules, and the Bangkok rules were very important in the UN system as providing a sort of a way towards amendment, because, as I've said, the 1955 UN standard minimum rules hadn't been amended for a half century. And the new rules about women prisoners that came out in the Bangkok rules provided a way into amendment. But Europe has not done that. There is no body of European recommendations concerning women prisoners. So after a lot of thought, we decided that all we could do there was really add a new first rule to the slightly longer rule on women, which is really a call to Europeans and, of course, member states, both at the European level and at the national level, to develop gender-sensitive policies and to take positive measures to meet the distinctive needs of women prisoners. I think there is scope for European rules of this kind, but if you want to go further than that general statement, reluctantly, I have to say the best place is to look at the Bangkok rules. Bangkok rules, I've been working with them again recently, go into considerable detail, and you can see that they raise a range of questions which are particularly important to women, but which are often not dealt with fully in all the other rules you have for all prisoners and could potentially apply to all prisoners. So women is one area. The next one is foreign nationals. Now, yeah, this was easier in a way, because in 2012, the Council of Europe adopted a comprehensive recommendation concerning foreign prisoners. And what we really needed to do there was to emphasize them a bit more in the European prison rules, and in a sense cross-refer to the 2012 recommendations. So we emphasize things like family contacts, early release, which are a particular problem for foreign nationals. The importance of foreign nationals across Europe is kind of obvious. There are far more foreign nationals in our prisons now than there were even in 14, 15 years ago when the 2006 European prison rules were adopted. So something ought to be done there. The fourth one, the fourth on my list, the instruments of restraint. Now, we have a very traditional rule, or had a very traditional rule, which listed a few instruments of restraint, some of which sounded as if they came out of not the 20th century, but the 19th, and said that you couldn't use certain forms of shackles and so on. The answer is that the technology has changed. There are more forms of restraint that one needs to think about. And what I really wanted was a stronger emphasis on policy principles. So we added some general principles of the way in which one should look at the use of restraints. Then requests and complaints that you've spoken about to some extent already today. This is quite, the changes here are quite technical. Rule 70, which deals with requests and complaints, I was comparing it briefly beforehand, is probably about twice as long as it used to be. There are far clearer changes which make it clearer what is expected of national procedures. And when you are amending your rules, as I've said, ideally your whole act, you should have a close look at this. Interestingly enough, this was one area where the pressure really came from the court and its representatives who took part in the gestation process of the rule amendments. And they said that there ought to be more clarity, because they often had questions that arose about whether there had been an exhaustion of remedies before the case came before the court, and the remedies were so unclear in many jurisdictions that they weren't good enough. So that we've given a clearer indication there really of what is expected. Then here is a little amendment which you would have, if you didn't know the rules very carefully, you would be find it hard to spot. I personally think one of the weakest sections of the European prison rules is the whole section that deals with prison staff. It was just not thought through. It has never been thought through in the various iterations of the rules in quite the level of sophistication one would require. And one of the problems that has arisen was what happens in a prison system if you have a national strike? This was a particularly difficult question in Belgium a few years ago, and the prisons kind of ground to a halt. They locked everybody up in their cells to let nobody out. And we thought we needed some rule to deal with operational emergencies and returning to ordinary standards at the earliest opportunity. Now, well, this was before the current pandemic, but many of the things that are debated so often now when one talks about prison law could be put under this heading as well. Then one of only two brand new rules that have been added has to do with prison records. Again, this may seem a mundane question to people who don't work in prisons. There's been enormous recognition in the last decade and more about the importance of data, record keeping, data protection, and so on, and privacy. And this has just become a hot issue across the whole human rights sphere. And to this extent, too, we needed more detail. And then finally, again, something that has been mentioned, much more emphasis on inspection and monitoring than in the early rules. The early rules, and I think we were wrong when we drafted them. We took a deliberate decision to keep it short and crisp. We were probably wrong. But again, the rise of OPCAT, the rise throughout Europe of national authorities, including in Ireland, has made it necessary that we have more details. And essentially what we did there is we looked at, in this particular case, we looked at what the Mandela rules had done, what OPCAT did, and we tried to extend it there. Okay, and this then brings me to what was really the most difficult issue in this whole area, namely the question of separation and solitary confinement. The 2006 prison rules say almost nothing about separation and solitary confinement, except in the context of disciplinary punishment. So what we had to do there was to rewrite the whole thing. Our initial idea was strongly to do something like the CPT had done, and make different rules for different types of separation. But this was shot down at a political level. And at the end, we were left with trying to write something reasonably crisp, and to do it particularly in the light of the Nelson Mandela rules, because though the Nelson Mandela rules are not perfectly formulated, they do make it very clear, they do make one thing very clear, that solitary confinement means having less than 2 hours of meaningful human contact a day, and that solitary confinement, the use of solitary confinement should be strictly limited. They don't say very clearly what separation is. In any case, what the European prison rules now do is they clarify all the strategies that you can use to deal with extraordinary safety and security measures in the General Rule 53. And then they have a brand new rule on separation. And separation is defined negatively. Separation is any form of keeping prisoners separated from others for the different reasons which we've mentioned, to deal with the threat to good order, to deal with the protection of a prisoner, or in the case of unsentenced prisoners, to deal with something a court may have ordered. And separation can be used, and Section 53A sets out a list of protections, but the most important one is separation should always allow for at least 2 hours of meaningful human contact, with the exception of where you're imposing solitary confinement in very limited circumstances as a disciplinary punishment. So we draw a very clear distinction between separation and solitary confinement, and separation has a list of protections spelt out in Rule 53A. However, and it's a big however, the hardest thing to do, and this took days and days and days of negotiation with the different nation states, was to come up with some limitation on the use of solitary confinement. And the crunch question here was the Mandela rules define solitary confinement, as we've said, as possibly less than 2 hours of meaningful human contact a day, but they limit solitary confinement absolutely to a maximum of 15 days. The CPT thinks it should be 14 days, but 14 or 15 days is no big difference. The difficulty here was that there was a group of countries that flatly refused to accept a day limit on how long solitary confinement would be. This group of countries, led by France, eventually said, we will block all the changes unless you take that out. And as these things have to be done by consensus, after, as I say, literally days of negotiation, it got stuck on that. So what Rule 60, Sub-Rule 6 now does is to try and limit the use of solitary confinement as carefully as it can without going to without going into this point. Mary, could I just finish explaining this, please? And it does it in different ways. So it first says it should never be imposed on certain categories of people. It then says that it has various limits on people who have health problems of various kinds, or who health gets worse while they're in solitary confinement. It should only be used for disciplinary purposes. And then there's a very important provision, Rule 60 sub 6 sub D says the maximum period for which solitary confinement may be imposed shall be set in national law. And here we go back to national law, your rules or your act again. And what is important here is that solitary confinement should never be a form of torture, should never be an affront to human dignity. How do you decide what is such an affront? Well, you look at what other people have said. And the Mandela rules have said, if you go over 15 days, that would be unacceptable. The World Medical Organization has said, if you go over 15 days, that would be unacceptable on medical grounds. The crunch here, and what will be legally interesting, is what countries do about this. Because we've made it perfectly clear, the European prison rule expects a limit. So if a country, and I'm sure Ireland would never do this, but if a country were to say, well, we will have 60 days of solitary confinement as a maximum, I would put a lot of money on it. The European Court of Human Rights would say that is not an acceptable law because it goes further than what this allows. The other safeguards, you can't repeat different periods of solitary confinement. There must be medical visits and so on, but that's the sum of it. And I think for a quick summary, that's the best I can do. Thank you very much.
Thank you very much, Dirk, for a really fascinating insight into that process and the negotiations, which I'm sure will be replicated in perhaps a smaller form here, and also for helping us to lift our eyes to the horizon to see where our national debates might fit in to the revision processes that we've seen you describe so well. So thank you very sincerely for giving your time and your expertise. I'm going to hand this over now to Fíona Chinnéide, Executive Director of the Irish Penal Reform Trust, who's going to close the session. Thank you.
Okay. I was just going to say I will keep you for just 3 minutes and then let you all off into what remains of this beautiful evening. Thank you all for engaging in this conversation today. It's clear what we have heard, that the review of the prison rules is an opportunity for positive change, one that can assist the prison service to meet its aspiration of being a world-class prison system. However, it's essential that any such review is not led by concerns of efficiency or practicalities, phrases we've heard so much today, like insofar as is practicable, but is instead led by a commitment to human rights, equality, and best international practice. And just to pick up on one of those comments there, we cannot say often enough that minimum rights and entitlements should not be targets, they are starting points. Earlier this week, the Department of Justice strategy statement included a clear emphasis on shared solutions and engagement with community and other partners. And the Director General of the IPS has also told us that there will be an opportunity in the review process, the review of the prison rules, for people to raise important points shared today, and we welcome that. Finally, I'd like Ireland to take up Dirk's gauntlet and be one of the first to set out in law a maximum limit of 15 days solitary confinement, by which we mean 22 or more hours lockup. So we'll see you and raise you on that, Dirk. It just leaves me to thank Professor Mary Rogan for so expertly chairing the event this evening, to our speakers, Damien, Matthew, David, Patricia, John, and Dirk. An additional thanks to Damien for his assistance to IPRT and updating our Know Your Rights Guide. Thanks to the Irish Criminal Bar Association for jointly hosting the event. Thanks to the Irish Prison Service and the Red Cross Prison Programme participants, so men and women in detention, who reviewed the revised edition of Know Your Rights. Thanks especially to Molly Joyce, our new Legal and Public Affairs Manager, who coordinated this amazing event this evening, aided and abetted by the IPRT team, Pamela, Lorraine, and Michelle, and our mighty volunteers, Agnel, Declan, Sean, and Shauna. We are grateful to all our funders who make our work possible, in particular the Community Foundation for Ireland and the Mercy Congregation Solidarity Committee. Nevertheless, IPRT relies on the support of our membership and donations to do our work. After this event, we'll be sending a link to all attendees and ask you to consider becoming a member, donor, or friend of IPRT. So thank you all for your support, and see you at the next one.